Hearing in the appeal, Shophold Mauritius Limited and the Assessment Review Committee and another.
Yes, Mr. Zachary.
Yes, may it please your lordships, appear together with my learned friends Jason Arel and Sandy Pulisami, and my learned friends Philip Baker QC, Karuna Ganesh, and Imran Afzal appear for the respondents.
Yes. Well, now we've read the cases. We consider that the principal point that we'd like to hear you on is the second point, rather than the first and the third. Of course, you may say what you feel you need to on those points, but the second point is the one which I think will occupy our interest most. Yes?
Thank you, my lords. I wish to inform your lordships that I, in fact, would not be pressing on the first point, that is the issue regarding the ARC's time.
Yes, well, we think that's sensible.
Yes. Lords, may I proceed, my lords?
Yes?
This appeal, my lords, challenges the decision of the Supreme Court of Mauritius, which had upheld the findings of the Assessment Review Committee, that is the ARC, which is the first respondent, and it concerned a claim by the Mauritius Revenue Authority, the MRA, which is the second respondent, my lords, and that was with regards to a claim for VAT in the sum of some 3 million rupees, which would be the equivalent of some £56,000 under the provision of the Mauritius VAT Act of 1998, which shall be referred to as the VAT Act. My lords, your lordships are certainly familiar with the facts of the case, but may I nonetheless highlight 4 salient features which I shall be using as the backdrop for my legal arguments, my lords.
Yes.
Firstly, my lords, in May 2003, the appellant passed what we refer to as the first resolution, whereby it waived its entitlement to management fees of 1% of ShopRite, which we know was its 51% subsidiary, until the latter would become profitable.
Yes.
The second salient feature, my lords, is that during the taxable periods 2003-2006 in question, the relevant period, no invoice was issued by the appellant to, nor any payment actually received from ShopRite or any other party in respect of those management fees. Thirdly, my lords, if I may, in January 2008, the Appellant's Board of Directors passed what we refer to as the second resolution, whereby the entitlement to the management fee was reinstated, being given that ShopRite was then trading profitably. And let us not forget that this was done retrospectively as from July 2006. And the fourth, and certainly not least point, my lords, is that there is absolutely no evidence on record whatsoever to suggest that this arrangement between the appellant and ShopRite was in any way a facade designed to amount to a tax avoidance scheme. My lords, I shall now address the 2 grounds which have been grouped together, namely the first one having been abandoned, therefore we shall look at the 2 others, grounds 4 to 8, which concern the issue of consideration, which your lordship very rightly pointed is the central point for determination for your lordships today, and that would deal with the interpretation and application of sections 9 and 4 of the VAT Act. And secondly, I shall look, my lords, at the issue of the time of supply, which relates in turn to the interpretation of section 5 of the VAT Act.
Yes, section 5 is quite an important section from your point of view.
Section 5?
Yes.
Very much so.
Yes.
I shall be, my lords, submitting, if I may, since your lordships raised the question, that this time of supply is central to the determination of the point in time when consideration occurs.
Yes.
But obviously I shall come to that.
Could I clarify one piece of factual background? You've given us 4 very significant factors. I can see why you've said them. Once the parent company retrospectively reintroduced the management fee, am I to take it that invoices were submitted and paid, and VAT was paid on those invoices?
That's exactly the question that I put to my learned junior, Mr. Harel, who was appearing before the court below and the ARC, and the answer is in the affirmative.
Yeah.
Yes.
Thank you.
So they were properly restored to all intents and purposes.
Yes, thank you.
The MRA didn't get back to us. My Lords, therefore, the grounds 4 to 8, my Lords, they challenge the Supreme Court's findings to the effect that the management agreement between the appellant and Shoprite remained active at all material times, notwithstanding the existence of the first resolution, which had resolutely waived payments for the management fees. And secondly, my Lords, the finding also that the 1% of gross turnover of Shoprite constituted consideration for the management services which were provided, despite the fact that no invoice had been issued and no payment received by the appellant. So these are the findings that I propose to meet head-on, if I may say, my Lords, and therefore the case for the appellants would be, my Lords, that the management services provided by the appellant was not for a consideration. Because, to repeat myself, pursuant to the first resolution, no payment, whether monetary or otherwise, was requested or received by the appellant from Shoprite or any other person. My Lords, the starting point in the discussion would be Section 9 of the VAT Act, and I here invite your Lordship's attention to tab 1, MS 206. And Section 9 is what we would call the charging section, in that at subsection 1, my Lords, it makes it amply clear that VAT shall be charged on any supply of goods or services made in Mauritius, where it is a taxable supply made by a taxable person in the course or furtherance of any business carried on by him. My Lords, for there to be VAT chargeable, for it to become a taxable supply, one of the conditions that this taxable supply must eventually be made for consideration. But may we, before we go there, not short-circuit the arguments, to say that we need to look at Section 2 and Section 4. Section 2 is at page 202 of the bundle, and Section 2 defines taxable supply. This is the definition section.
Yes.
Means a supply of goods in Mauritius or a supply of services. I would say that Section 2 is more of a general nature, of an all-englobing nature. However, the relevant section for the definition for our purposes, my Lords, would be Section 4, which is to be found at page 203.
Yes, because Section 2 says supply has the meaning given to it by Section 4.
By Section 4. So, yes. But nonetheless, I felt that it would be good to start from the beginning, from Section 2, which leads us to Section 4, rightly. And subsection 4.1, my Lords, is concerned with the meaning of supply. And we go to B because A is concerned with, in the case of goods, but we are here dealing with services. So 4.1b is that supply means, in the case of services, the performance of services for a consideration. And 4.2a and b, likewise, lay emphasis on the notion of consideration. 4.2a, supply in this act includes all forms of supply, but not anything done otherwise than for consideration. Likewise, b, anything which is not a supply of goods, but is done for a consideration. So there we have it, my Lords, the notion of consideration comes in. So that if we read Section 9 and 4 in conjunction, we were to make a juxtaposition of those two sections, my Lords, it would mean that VAT may only be charged if and only if the supply of services is made in respect of the performance which is being done for a consideration.
Well, your argument in the sentence really is that if you're not paid for the services, then it cannot be a supply within the meaning of the legislation.
Yes, there must be a direct link between the supply and the consideration. This is, in fact, what the case law will be making clear shortly.
Well, it depends, doesn't it, on what meaning you give to consideration.
Yes.
If by consideration you mean that which is necessary to support the validity of a simple contract, then there was the mere obligation supplied the consideration. On the other hand, if you mean a consideration of value, and in respect of that value the VAT is chargeable, the result may be different. On the face of it, section 12, 2 and 3 appear to indicate substantial consideration is envisaged and not simply that which makes a contract valid.
Subsection 12(3).
2 and 3 deals with the assessment of VAT and distinguishes between cases where the supply is for a consideration in money, a mere obligation is not necessarily a consideration in money.
Yes. Well, the answer to that, my lords, is that the view of the appellant in this case is that the consideration should consist of money or money's worth which is actually received.
Yes. But I think that is Lord Sumption's point.
Yeah.
Yes.
If it's not actually received, it's difficult to see how that can be chargeable as a proportion of it.
Exactly.
Yes, and even if there is, I shouldn't say even if there is, because there is, there's a possibility of separate meanings of consideration. You have to look elsewhere in the Act to see what it means.
Yes.
One place is Section 12, as Lord Sumption has said. The other place, which you'll be coming on to, is Section 9.2 and Section 5.
Yes.
Yes.
I thank your lordships for your very pertinent remarks. The Mauritius tax laws, my lords, in fact provide no definition for the notion of consideration, and it would therefore be apposite in this respect to turn to English and European law for guidance. And in fact, my learned friend for the respondents agrees at paragraph 12 of his case that we may appropriately do so. In the case of Director General of the Mauritius Revenue Authority and the Central Water Authority, which is a judgment of your lordships Kerr and Sumption, your lordships, in fact, reinforced the proposition that we may indeed turn to UK case law and the European Court of Justice.
Which tab?
This would be tab 11, my lords, at page 301. And that would be paragraph 4, if I may quote, my lords. Mm-hmm. The fourth line of the paragraph, the VAT Act 1998, that is the Mauritian one, is framed on a significantly condensed basis on the general model of the United Kingdom, VAT Act 1994, which in turn gives effect to the European Union requirements, initially under the Sixth Council's Directive of 1977, and since 1st January 2007, under the Council Directive 2006/112/EC. The CWA thus relied below upon case law of both the UK courts and the European Court of Justice in support of its analysis and of its applies to its customers. The general value of such case law was not disputed in relation to the issue on this appeal, although care need to be taken in other cases before supposing that the effect of Mauritian and United Kingdom and European legislation will always coincide, bearing in mind in particular the differences in their working at a detailed level. Of course, there is a word of caution which is sounded by your lordships in the judgment, but I shall be mindful certainly of that. This being said, my lords, I propose to turn first to the English doctrine and case law. Our starting point would be Tolley's value-added tax, and this, my lords, is reproduced at tab 13, pages 318 to 320. I shall summarize the propositions made by the learned author, my lords, as follows. Firstly, is there consideration? And under both EU and UK law, a supply takes place for VAT purposes when something is provided for, something is provided or done for a consideration. So there we are aligned with the English principles. B, if there is no consideration, is a transaction one which is deemed to be a supply for VAT purposes? Even if there is no consideration, the author goes on to say, there are certain transactions made for no consideration, that is for free, which are deemed to be supply of goods or services for VAT purposes. No such list, my lords, exists under Mauritian law, so we may usefully discard this exception. C, my lords, does the transaction fail to be a supply, or is it a supply which is disregarded for VAT purposes? Again, to repeat myself, it will be submitted, my lords, that the present transaction fails to be a supply for reasons which I have already given and I did not go again into.
Well, it's the first bullet point there that you're founding on.
Yes. My lords, I have come across the latest pronouncement of the UK Upper Tax Chamber, and this is the case of Norseman. This is not in my bundle, my lords. I have, through my instructing solicitor, made copies available for your lordships, and to my learned friend also. Your lordships are being provided with a copy of both the first tier tribunal as well as the upper tribunal. I shall be referring to the upper tribunal's findings, my lords, on the issue of consideration. Thank you. My lords, sorry?
Yes?
Okay. My lords,
I have copies, my lord, yes.
Yes, thank you.
I just asked my learned friend if perhaps he would refer to a paragraph in the first tier tribunal, but perhaps I'll deal with that.
yes,
Yeah.
You may do so later. My lords, the upper tribunal examined the question of whether management services provided by Norseman, that is the Appellant, with subsidiaries, was made for consideration and were hence taxable. The facts of this case bears certain similarities to ours in that no invoice was ever raised, nor any payment actually made in relation to the management services provided by Norseman during the relevant tax periods, as the subsidiaries, there was more than one, were incurring losses. And these facts are reproduced at paragraphs 23 and 26 of the judgment. Now, the difference, however, my lords, is that the court found as a fact that there was a rather vague intention to levy an unspecified charge by Norseman at some time in the future, and that was not enough to establish the existence of consideration. Now, I shall be likening this to our case, my lords, on the ground that in our case, the agreement was non-existent to the extent that it had been suspended. So likewise, I will be submitting, my lords, that there was no agreement, just like the court in Norseman held that the absence of specific modes of payment did not amount to consideration.
Well, there clearly was an agreement. You say it was suspended. What do you mean by that? Do you mean that Could they have subsequently said, well, the company is doing better than we thought, we will charge a management fee after all, which is effectively what they did say in 2008, going back to 2006. If they had decided to do that in 2006, going back to 2003, could they have done so?
Well, I would say to this, my lords, that that would depend on the actual facts of the case.
Of course. But I mean, on the face of it, the facts of the case were no different in 2006 to what they were in 2008, except that the board made a different judgment about the fortunes of the company.
Yeah. And also, to the credit of the board, they backdated the payment.
Yes.
From 2006 onwards. And the fact also remains that there is no evidence to dispute the fact that the company was not profitable during the taxable years.
Yes, well, it doesn't matter what their reasons were. The fact is we know that they waived payments and that later in 2006 they retrospectively said, well, we're going to charge it anyway. And on the face of it, they could in 2008 have said, we'll go back to 2003 rather than 2006. So it looks as if there was an agreement, there was an obligation, enforcement of which was waived,
Yes.
but no actual payment. It may be, therefore, that the non-payment is more significant than the non-agreement.
I mean, the case I think you have to meet is this, that an obligation existed. You chose to waive that your right, the counterpart of the obligation. Therefore, no management fee was charged or paid. And the government is saying that is sufficient to give rise to an obligation for VAT. And you're saying, no, it isn't, because there has to be actual payment.
Yes.
And as you'll be coming on later, you'll be praying in aid, I imagine, sections 9, 2 and 5 to show that.
Yes.
Yes. Thank you.
My lords, there is a very interesting passage in the case of Norseman, but before I go there, maybe it would be interesting to note that the difference between our case and Norseman was that it was the tax authorities and not the taxpayer in Norseman who was arguing that there was no consideration for the supplies. And the reason being that the taxpayer wanted to avail itself of the tax credit to do so. This is in fact the irony of it in that case. Well, be that as it may, my lords, may I perhaps now turn to the operative passage which bring to your lordship's attention in the Norseman case. And I'm here referring, my lords, to the passage at 119 at page 46 of the judgment, my lords.
Yes.
Now, in relation to the central issue concerning the necessary link between payment and supplies, there are two logically distinct questions, although the answers to each go together. The two questions address the separate limbs and so on. The first question is whether the supplies actually made by Norseman in the relevant period were made for consideration and were thus taxable supplies when made. And the second question is whether there was, before or during the relevant period, an intention to make future supplies. And paragraph 120, my lords. The answer to the first question is, in my view, that the supplies were not made for consideration, they were made gratuitously. Test this matter this way. Suppose that the evidence had established that before any supplies at all had been made, Norseman had formed the clear intention to charge the full cost of the supplies to its subsidiaries. Clearly, Norseman would then be an intending trader, and the supplies, when actually made and paid for on that basis, would be taxable supplies. This, my lords, that test, that first situation, the first cas de figure, is on all fours with our case, pre the first resolution and post the second resolution. And then credit of input even if incurred in a period, we're not really concerned with this. But let's look at this second cas de figure. But suppose that the actual supplies were made without payment, it being agreed at the time with the recipient of the supplies that they would be free of charge for some good reason. I do not consider that it could possibly be maintained that the actual supplies were made for consideration, simply because they had, at an earlier stage, been an intention, not in fact implemented, to make this supply for consideration. And this, my lords, take us in this situation between the two resolutions in my humble submission.
Well, the difficulty about that is this is distinguishing between a unilateral intention to charge and a legal liability to pay. In a sense, this may be against your first submission, because what is being said here is that the intentions of the potential charger are irrelevant. What matters is the legal obligation. The point made against you is that the board waived collection of the charges but did not amend the agreement, so that the obligation to pay continued, albeit that it was not enforced.
Well, to this, my lords, I have in my case, and I'll be submitting also, that there was no need to perfect, as it were, this resolution. This is my first point. I'll come to that.
It's not a question of perfecting it. It's the difference between deciding not to exercise your rights and amending the underlying agreement so that those rights cease to exist.
Well, to that, may I reply, my lords? Was there a need in law to amend the agreement, or could it be inferred by way of the relationship between the parties that it was not necessary to do so in view of the fact that ShopRite was a 51% subsidiary consisting of the same directors, and that they would be deemed to be aware of that fact? And as a matter of fact, if we go even further, my lords, we know for a fact during that at least 3 taxable years, no charge was made to them, nor payment made by them. So they would obviously be certainly aware of that. So my answer to that, my lords, would be that one should not be burdened by the necessary legal constraints which normally apply in the case of a principal dealing with a subsidiary. In fact, my lords, this point, if I may, is addressed in Norseman. That would be at page 12. Let me just... page 12, paragraph 33.
Paragraph
33. No, I'm sorry. It's
paragraph 33 is setting out the
no, I'm
73
sorry,
of the principal VAT directive.
It is at page 24. Okay. Page 24, paragraph 64, my lords. Midway down the page, my lords, I quote, "The tribunal accepted that it is not realistic to expect that the manner in which lending and management activities are undertaken intra-group will be strictly comparable to the way in which they would be undertaken between third parties. A lack of sophisticated documentation does not mean that the services are not being provided on a commercial basis." And further down, my lords,
what are you submitting? Are you submitting that, in fact, this was tantamount to an agreement that the money could not be charged?
Indeed.
Then on what basis in 2008 did they charge it going back to 2006? On the face of it, they weren't entitled to.
In just about the same manner. In just about the same manner that
There
it was
was a
done.
new agreement, was there, in 2006, retrospectively entitling them to charge. It sounds a little artificial, if you don't mind my saying so.
And in any event, there was no exchange between the relevant parties. This was a unilateral resolution by the board, wasn't it?
Yes, but as I just stated, my lords, the decision that was taken in 2008 was motivated by the fact that ShopRite had become profitable.
Yes, but it was only possible to make that decision because the obligation was still there, so they could enforce it.
Well, to answer your lordship's previous question as to whether it was incumbent on the parties to refresh, so to speak, or to amend the agreement, be it in 2003, the first resolution, or 2008, my answer would be the same, my lords, that because we were dealing with two groups within the same company, to use the dictum in the case of Norseman, and because the parties were certainly aware of their situations, that is the profitability, that is the time at which in 2008 they deemed it fit to backdate the payment of the VAT charges, I would humbly submit that the parties could be dispensed of the need, of the stringency of the law to make another agreement. And if I may, my lords, the citation at page 24 goes on, and I quote, "The tribunal has concluded that the provision of management services for what was essentially a fixed fee based on what the subsidiary could afford cannot be treated as a taxable supply." So, in essence, my lords, the case of Norseman, in my humble submission, does away with all these legal formalities. And when applied to the present case, it certainly could dispense the appellant from making any further agreement. My lords, on the intention of the parties, I was also asked a question on that. May I refer your lordships to the judgment of Norseman, that is at paragraph 123. That was on the second question, my lords, that was put, namely, whether there was, before or during the relevant period, an intention to make future supplies for consideration so that such supplies would constitute taxable supplies. So that was the question and the answer, and I quote at 123. As to the second question, I agree with Ms. McCarthy that an intention merely to make supplies is not a sufficient basis on which to recover input tax. What needs to be established is an intention to make taxable supplies. And further down, but the important point for present purposes is that the intention, which must be shown to exist, is one to make taxable supplies, that is to say, supplies for consideration. And it would be my submission here, my lords, that the appellant had the intention to make a taxable supply under the management agreement.
The test is surely whether there is a taxable supply.
Yes.
It doesn't, I mean, if you intend to make a taxable supply but don't, no VAT is chargeable.
Yes. But obviously, on the one hand, we have, in our case, suggested that it was not a taxable supply. But on the other hand, even assuming it was a taxable supply, the case of Norman introduces the notion of intention, and is the passage, my lords, is to the fact that there must be that intention. And we are saying that that intention was lacking during the taxable periods. The intention was certainly there before the first resolution. The intention was certainly there post the second resolution, my lords, and it would therefore be submitted that during the intervening period, that is the taxable periods, the appellant had an intention merely, and I'm here using the phraseology coined in the case of Norseman, my lords, that during that intervening periods, the appellant had the intention merely to make a supply and not to make a taxable supply.
Well, I'm not sure if that language helps you, because in your VAT Act at section 4.1b, supply is defined as the performance of services for a consideration. So using your statutory language, you didn't even intend to make a supply because you didn't intend the supply to be for a consideration.
No, in fact, your lordship is very right, absolutely right. But this argument was being put forward as an alternative to the main argument that there's no taxable supply. My lords, at paragraph 13, and I'm here referring to the case of Trafalgar Tours, which is the second English case. This is a case cited by my learned friend, paragraph 13 of his case.
This is tab 8.
Yes, this is tab 8, page 275, paragraph G. My lords, the paragraph G reads as follows. However, regard to Article 11A of the 6th Directive, we are therefore subject to one important qualification, prepared to accept that the expression consideration in Section 10.2 of the 1983 Act means everything...
Sorry, what you're reading from? Forgive me.
I'm reading, my lord, from tab 8.
Yes, which page?
275.
MS 275.
MS 275.
Internal page 135.
Yes.
At letter F, Article 11A1A
Yes,
is quoted, and then
Yes,
it's discussed in the passage you're reading.
Means everything which the supplier has received or is to receive from the purchaser, the customer, or to a third party. Now, the question that needs to be discussed here, my lords, is whether the term or to be received is applicable here. It is my submission that it is not. In fact, your lordships will note that in the case of Norseman, the same notion, the comparable notion under English law, that is page 12, paragraph 33 of the judgment. The notion in that case was or to be obtained. Your lordship will find that, which constitutes consideration obtained or to be obtained. In the case of Norseman, my reading of that case is that the learned judge, Justice Warren, interpreted it on the facts of the case as consideration which was actually obtained, but not.
Well, and I wonder about that because, I mean, Article 73 of PVD, to which reference is made by Mr. Justice Warren in Norseman, is in a sense is essentially the same text as Article 11A1A of the prior directive in Trafalgar Tours. And it seems to me in Mauritian law that the same will apply, because if you issue an invoice before it's paid, you have a taxable supply.
Yes.
So it is obtained or to be obtained. Your point, as I understand it, is if you have waived the issuing of the invoice and haven't issued the invoice, then it is not to be obtained at all.
Indeed.
Yes. So you don't need to airbrush away these words. All you have to say is, absent, if we've decided not to issue an invoice, there is nothing to be obtained.
Indeed, Will. So my point is that one cannot prospectively rely, so to speak, on this passage to say that such tax is to be claimed from the appellant.
Yes, you say the contract isn't enough if a decision has been made not to enforce it, and therefore no invoice issued. That's, I think, the nub of your case.
Indeed.
That's quite consistent with there being a taxable supply.
Yeah.
It's that you've got two quite distinct arguments here that one needs to think about separately. One, you say no taxable supply. Two, even if a taxable supply, no consideration to which the provisions of sections 5, 9 and 12 could apply.
My Lords, may I maybe just briefly distinguish the case of Trafalgar Tours, my Lords, in that when one, in fact, goes on to the next passage, paragraph H, it is abundantly clear that this paragraph G was being put forward within the context of the specific facts of this case, namely where the appellant Trafalgar had been organizing tours, and they had, and contrary to this case, as your Lordship will remember from my opening, the customers had paid to the appellant's parent company. And the issue, and this was done by way of a tax avoidance scheme that was found as a fact, which is certainly distinguishable in our present case. And secondly, payments were actually made in that case, which is again distinguishable.
Yes, I mean, what the passage at G to H is concerned about is where the supplier itself didn't receive the consideration, but others did.
Others.
But arranged for it to be
So the
received
short
by someone
point, in
else.
fact, was whether it was as good that the person receiving it on his behalf was...
Yes. I mean, consideration,
Bind the appellant.
consideration passed to others who received on behalf of the supplier. That was the outcome of that case.
So therefore, in my submission, we can leave Trafalgar as it is then. Now, my Lords, when we turn to European case law now, my Lords, we have to start with Tolles again, and this time it is at tab 13, my Lords, MS 320. That is the penultimate tab, my Lords, at paragraph 71.8. My Lords, their consideration is under consideration. The consideration is not defined either in Directive 2006 or the VAT Act. The word was defined in the second directive as meaning everything received in return for the supply of goods or the provision of services, including incidental expenses, packing, and so on and so forth. And then, even though the directive no longer exists, the definition is still sometimes used in cases brought before the European Court of Justice. The phrase "in return for the supply" is interpreted to mean that there must be a direct link between the supply and the consideration. And reference is there made to the case of Staatssecretaris, which is otherwise known as this potato storage case. Your Lordships are certainly familiar with the facts of the case. I did not go into them. But suffice it to say, my Lords, that in that case, the court found that there was no direct link between the service provided and the consideration. The court also found that such consideration, and this is at tab 5, page 238, my Lords,
Could I just draw your attention to the circumstance that since you've abandoned them, in our view, correctly abandoned the first point, and since this case must finish by lunchtime, we would expect you to end at 12 o'clock, if not before.
Oh, yes, I shall do so.
Yes.
So, my Lords, I shall briefly, therefore, refer to the ratio in staff secretaries, that is a potato case, where it was said that this consideration is a subjective value since the base of assessment for the provision of services is the consideration actually received.
Which paragraph are you reading from?
This is, my lords, paragraph
Page?
page 238, paragraph 13. That is the last line, last but one line. Such consideration is a subjective value since the basis of assessment for the provision of services is the consideration actually received and not a value assessed according to objective criteria. So I lay emphasis on this, my lords. My lords, the potato case presents certain common features with our case. Firstly, my lords, is that the appellant here, just like the cooperative society in the potato case, decided not to impose a charge to VAT when it had authority to do so. Secondly, my lords, the tax authorities in both cases have created what I would call a legal fiction, whereby although no money or money's worth had actually been received or requested for, the consideration was computed on the basis of, to use the words of the Supreme Court, my lords, of what ought to have been received. And in the potato case, that was computed on the basis of the reduction in the value of the members' shares, owing to the non-collection of their storage charges, whereas in the present case, my lords, it was calculated on the basis of the 1% turnover of ShopRite, despite the existence of the first resolution and despite the fact that no fees whatsoever had been received. My lords, the Supreme Court, in fact, reinforced this legal fiction by holding, and this is at page 88 of the record, my lords, and I quote, that the appellant ought to have received payment at the end of every month. My lords, it will be submitted that the potato case, when applied to the present one on the notion of actually received, and this notion of the legal fiction being created, cannot find its application in the present case. My lords, may I now perhaps turn to another case that was cited by my learned friend at tab 9, MS 283, the case of Tolsma.
Yes?
The case starts at tab 277. My lords, in that case, my learned friend referred to paragraph 14 of the judgment, and this is what the case of the appellant respondent has to say, that for the proposition that there must be a legal relationship between the provider of services and the recipient to which there is reciprocal performance. I could not agree more, my lords, but I must say that this citation is incomplete because it somewhat conveniently misses the main point here. Because when we go on, when we read on, what the judgment says, and I quote, which there's reciprocal performance, comma, the remuneration received by the provider of the service constituting the value actually given in return for the service supplied to the recipient.
Yes, I mean, what Tolsma is saying is looking at the matter from the viewpoint of the supplier and saying, has the supplier been paid for the service which it has provided? That's what that paragraph's about.
Yes.
And you know, whether he's been paid by the recipient or by a third party, what Tolsma is looking at is for a direct link between what the supplier has given and what the recipient has received.
The point I was making, my lords,
Has given and what the supplier has received in return.
was on the qualification of the actually, on the value actually.
Yes, well,
I think that's the point my lord is making to you. Yes?
Yes. And therefore, my lords, I shall then now, my lords, move on to the second ground,
Yes?
which is the third ground, the original ground. And this ground, my lords, was dealt with by the Supreme Court at page 86 of the record as follows, and I quote, "In effect, what the committee found," page 86, "In effect, what the committee found,"
which paragraph are you reading from? Which page 86, you say? Of the internal page 86, or?
But this is all related to ground one, isn't it?
yes,
I mean,
I thought you'd abandoned ground.
I don't see how ground three can have legs if ground one doesn't.
no, it's related to ground two.
Sorry?
It's related to ground two.
I see.
Ground one was the one related
Yeah.
to the time limits.
Well, it's related to the ground that you've just dealt with. Perhaps you can tell us how it's related to that.
Well, it is related, my lords, in the sense that the Supreme Court found, and I quote, that in effect what the committee found was that under Section 5 of the VAT Act, even if Shophold did not raise any VAT invoice, it ought to have received payment for the service at the end of every month as per the agreement. That disposes of ground one, ground four. Well, in so doing, my lords, the Supreme Court was merely rubber stamping the findings of the ARC on that issue. And the grounds, my lords, 9 and 10, they challenged the findings of the Supreme Court that VAT was payable despite the fact that no invoice was raised or payment received.
Well, however you categorise it, I think we do have to look at section 9.2 and section 5 of the Act, so let's do so.
Yes. So
Section 9.2 says VAT on any taxable supply is a liability of the person making the supply and becomes due at the time of the supply.
Yes. So the time of the supply, my lords, is most relevant. In fact, this is confirmed by the dictum in the case of Norseman, tab 14, page 320. No, sorry, not in Horst Norseman. But rather in Devoil, my lords. That is the last tab,
Yes.
tab 14, where the author has this to say that whether or not a supply is made for a consideration is determined at the time of supply. So my argument here, my lords, is that under Section 5, which defines time of supply, and here we have to turn to page 204, tab 1, we have two times of supply which are provided for. If your lordships will kindly bear with me. First, under 5.1a, and second, under 5.1b. 5.1a is at the time the VAT invoice is issued. Under 5.1b, at the time payment for that supply is received, whichever is the earlier. So we have 2 points in time. I believe they're referred to as tax points, 2 tax points, that is 5.1a invoice, 5.1b payment. This pattern, my lords, is reiterated under subsection 2A and B. And subsection 2, my lords, deal with services which are supplied for a continuous period under any enactment or agreement which provides for periodic payments. Arguably, the appellant's situation would fall under 5.2. And again, we find it's time of invoice, time of payment. And lastly, my lords, subsection 3, B1 and 2 has the same principle. So the point I'm making here, my lords, is that the VAT Act contains two and only two tax points whereby VAT becomes chargeable, that is, time of supply and the payment. There is, however, one exception, and it is interesting to note, which is under section 5.3a, that is, under a hire purchase agreement, the supplier shall be treated as a supplier of goods and it shall be deemed to be supplied at the time the agreement is made. So this is one exception provided by the legislator.
Well, I note in 5.1 that the general provision setting these two times is subject to other provisions of the Act.
Yes.
But subsection 2, which you say is the one that would apply to you,
Yes.
isn't subject to that. So you say that's an absolute rule.
Indeed, my lords. And the point I will make here, my lords, is that one cannot travel outside those two specific tax points that have been laid down by the legislator. I say so, my lords, because it would otherwise mean that the Supreme Court found, when it found that the payment, that the consideration consisted in the supplies having been made at a time that it ought to have been received under the agreement, but was not actually received. In so doing, my lords, the Supreme Court was created yet another category. That is the category, that is the time for that supply ought to have been received, but which is not under the tax point which is envisaged under section 5.1 or 5.2. We may disregard usefully 5.3 because that deals with hire purchase agreements. And what more, my lords, it would further offend logic, because as I put it in my case, my lords, it would amount to a deeming provision.
Yes. I mean, your case put simply, as I understand it, is that 9.2 says that VAT is a liability that becomes due at the time of supply, and 5.2, which applies to your circumstances, doesn't arise. Therefore, there is no VAT due. I mean, that in its simplest form is what your case is it not? Yes.
But also upon the construction of the statute here, we find that we are concerned with only two tax points, and one cannot import within these 2 points a further point which was not contemplated. Had the legislature intended to make amends to that, he could and should certainly have been in a position to do so. As your lordships will appreciate from MS 205, this is subsection 5, my lords, of the Act, that notwithstanding the other provisions of this section, the minister may, by regulations, make provision with respect to the time at which supply is treated as taking place.
I think we have that point, and I think you've reached the end of your period.
Yes. On this note, my lords, I rest my submissions, unless, of course, your lordships.
Yeah, thank you very much indeed, Mr. Butcher.
Thank you.
Mr. Harold, do you feel? Mr. Baker.
These lordships, I think I can be very brief in reply.
Sure.
There are, in a sense, two fundamental errors that the appellants make under this appeal. The first error is that they assume that there can only be a supply if a payment is made in cash or cash equivalent. Obviously, that will usually be the case where a supply is made, but there can be a supply for consideration even if no payment is ever made, it's clear that consideration can be in a form other than cash.
Well,
And
that's
then
clear
say it's
from
not-
section 12.3.
Section 12.3, exactly.
But there's got to be some value, hasn't there?
Absolutely.
Money or money's worth.
And the value here arises from their second error. It's a failure to come to grips with the fact that there's a finding of fact, not now disturbable, from the Assessment Review Committee, confirmed by the Supreme Court, that the unilateral resolution of the parent company did not amend or vary the management agreement. So the subsidiary, Shoprite, continued to have the legal obligation to pay for management services, even though the parent had suspended the payment for their services by its first resolution.
So what do you say the consideration was?
The consideration was the obligation to make payment for their services.
Yes,
Obligation
so
to pay
the numbers, you say the existence of the contractual obligation is sufficient.
Yes, my lord.
So
That's the...
on that footing, suppose that they had said, okay, this is a taxable supply and its value is 0, so we're going to invoice them for nil. What VAT is payable on that?
That would not have been consistent with the agreement. The agreement was that there was a taxable supply for a consideration equal to 1%. They did not reduce that down to 0. They waived their right to claim that payment,
Yes.
but the agreement was not varied, and that's...
Well, are you saying that if a supplier decides not to charge, in spite of having a legal right to charge, that he has an obligation to invoice that which he would be entitled to charge, even though he hasn't done so?
Yes, my lord, I think that does follow from the legislation.
Right, now can you
Once
tell me where you
accept
find
the
that?
finding of fact that you have to, that there was a continuing legal obligation to make payment, then it must follow that the VAT Act, that's section 21, requires, 21,
Well, I'm looking at
20,
section-
requires the issue of an invoice.
Yes, I'm looking at section 20 sub 1, and it's part of the premise of my question that there is a continuing legal obligation to pay. So on that assumption, where do you get the obligation to deliver an invoice for a price which you do not propose to charge, simply because you would be entitled to charge it?
Because there is still a taxable supply, because there is consideration, because there's an obligation still existing in the agreement. But you can issue an invoice, but say payment is not currently required, but it may...
What would the invoice say?
The invoice would say the charge for this month is X. Payment is not currently required as by virtue of our resolution.
So you say that VAT is chargeable on obligations and not on payments?
It is not necessary that there should be a payment for VAT. VAT is chargeable on a taxable supply, and a taxable supply is a supply made for consideration. And the finding of the ARC establishes that the agreement remained in place, and so the obligation on the one hand for the parent to make the services available, and on the other hand, your Lordship, I think, hit the point exactly on the nail earlier when you said, could they have reinstated the payments not back to July 2006, but back to 2003? And the answer is, legally, yes, they could have been able to.
Well, I don't have any problem about the concept that the obligation continued to exist. I have potentially two problems. One is that I am not persuaded at the moment that the consideration to which the Act is referring is a mere obligation to make a payment as opposed to the actual consideration. And secondly, even if it is, I have some difficulty in finding in the Act, I may not have looked hard enough, anything which says that a VAT invoice in respect of a taxable supply has got to specify the value that would be due if it was decided to charge, as opposed to the value that is actually due, it having not been decided to charge.
Well, on the second point, the invoice must show the amount of VAT due, and the amount of VAT due in this case relates to the obligation which was continuing throughout.
Well, where'd you get that?
The subsidiary to the content of the VAT invoice.
And the rate is chargeable on the amount invoiced.
Excuse me, my lord.
The rate is chargeable on the amount invoiced.
Yes, but subsection 2 says a registered person who issues a VAT invoice shall specify that invoice the value of the supply exclusive of VAT. We know the amount of the value of the supply here because that's in the agreement which continues all the way through.
Well, that's, I mean, the value of the supply is surely the same as the consideration, except in a case covered by section 12.3,
yes,
where the supply is given for a consideration in money's worth other than cash.
well,
Isn't
not
that right?
consisting or not wholly consisting of money. It's the opening value of the supply.
But I mean, it's difficult to talk about the consideration consisting in the obligation in the context of section 12, isn't it? Section 12 envisages two possibilities. One is that the consideration is in money,
Yes.
and the other is that the consideration is in money's worth other than money.
Yeah.
Now, both of them assume that some value is supplied.
Forgive me, Lord, to interrupt you, but may I just say that I'm reading section 12.3 correctly? If the supply is for consideration not consisting or not wholly consisting of money.
Yes,
So it's for something which is not,
exactly.
or not wholly money.
It's
So-
considering some value
Yes.
by way of consideration other than money.
Yes.
Now, that suggests that the value in question is the value received, whether it's received in cash or in kind or some other form of money's worth. It's not easy to apply sections 12 sub 2 and sub 3 if the mere existence of an obligation is the consideration. This is concerned with consideration which is actually passing.
Yes. And each month as the services were supplied and the agreement remained in force, the parent had the right to claim that payment for that month equal to 1% of the gross turnover for that month. They chose to suspend those payments until 2008, when they then backdated them to 2016.
I'm not sure that this actually is directed to my point. My point is that on the face of it, subsections 2 and 3 of section 12 indicate that the consideration which is relevant consists of the value which is actually passed rather than the value which might have been passed had the contract been performed.
Well, the contract was performed on the side of the parent.
Yes,
and the value of the supply by the parent is given by the agreement, and the agreement is to pay a 1% of the turnover for that. So we know the value of the supply by the parent, and there was an ongoing obligation to make that payment in return, which we say it must follow that there is a consideration flowing from the subsidiary.
Mr. Baker,
I think with contract law there is
I think you may be confusing two different senses in which the word consideration is used. In the law of contract, consideration is a condition of the validity and enforceability of a contract. That is one sense of the word. In the VAT legislation, it seems to me on the face of it that the consideration is the value that actually passes, which is not the test when you are asking what will support the validity of a simple contract. Your submission that the obligation continued to exist is only relevant in the first sense of consideration. It's not relevant in the second.
With respect, my lord, I understand the distinction that you made, and I think it was one of your first comments to my learned friend there. Here, the obligation is consideration in both senses. It is consideration both as a matter of strict contract law. It is also consideration within the terms of Section 12 and the VAT legislation for two reasons. First, a factual reason arising from the finding of the ARC and the Supreme Court. Secondly, from the meaning of consideration as explained under European law, which, as we've common ground between us, can be used. I can come on to the second point, but it's summarized in our case. The requirements that the European courts have established for the definition of consideration, given that the different language versions of the VAT legislation, some use consideration, some use alternative terminology, but the case law establishes essentially 4 points for the meaning of consideration, and we satisfy all of those 4 points, and I can take you to that separately. But let me come back to my first point, which is what value passed from ShopRite to Shophold. And the answer is what passed was the obligation, the value of the obligation to make that payment, which at any point in time, Shophold could have resuscitated and said, well, you're now in a financially good position. You can now make payment to us. Before they did that, it doesn't mean to say that there wasn't any value passing to them. It's just that they hadn't actually asked for payment of that value.
I'm at a loss to see what value passed from the recipient of the supplies to the supplier of the supplies, simply by virtue of there being an obligation to pay.
But that is the normal situation, my lord, where there is any supply made on credit. If I buy an item on credit, I have simply undertaken an obligation to pay. The supply occurs at the time that an invoice is issued to me. The fact that I don't pay for some time or that I never pay does not stop there being a supply.
That's quite right, because the invoice is an invoice for sums due which will prospectively be paid. But to apply that to a situation where they won't be prospectively paid because it's been decided not to charge.
Well, respect my lord, we don't know that they weren't going to be paid because until the Shophold could have at any point in time reversed its resolution. It did so, and it reversed it with retrospective effect, and it could have done so. There's no legal reason why it could not have done so right to the period of 2003. That's
but it didn't.
Pardon?
It didn't reverse it between 2003 and 2006. It didn't issue an invoice and nothing was paid.
Well, your argument really resolves to this, that the value of the supply was the monthly indebtedness that continued to increase month on month.
Precisely.
Which could be activated at any time.
Precisely.
The contrary argument is that put to you by my Lord Hodge. Absent that activation, was there in fact any supply?
The activation certainly occurred with regard to the period from 2006 onwards.
Yes.
But prior to that time, as your lordship says, the liability is accruing month by month. Therefore, there is, we say, consideration passing because of the liability accruing. Therefore, there was a taxable supply. The logic from that is that, therefore, there should have been an invoice issued.
Logic is one thing, the provisions of the Act are another. At what time do you say that in this statute VAT became due?
VAT became due each month as the terms of the contract gave rise to a right to claim the payment of the 1%. And on that basis, an invoice should have been issued. I think your lordship is troubled by the Section 5.
Well, I mean,
point.
Section 9.2 seems to be in very clear terms that VAT on any taxable supply is a liability of the person making the supply and becomes due at the time of supply.
Yes.
And then 5.2 seems to tell us what the time of supply is. And I just wonder, how do you get round 9.2 and 5.2 to have this other time of supply, which is that you ought to have paid, you ought to have submitted an invoice?
There are, I think, three answers to the Section 5.2 point, and we're not reading into the legislation and ought to have paid. We're bringing the provisions of the legislation together and pointing out the obligation to issue an invoice. There are two answers to the Section 5.2 point there, and if I can start with 5.1, and then I'll draw the analogy with 5.2. 5.1a refers to an invoice is issued, but if you follow through the finding of fact that there was a continuing obligation to make payment, which was simply suspended, then it must follow that there was consideration, therefore there was a supply, therefore Section 20 requires that an invoice should have been issued. The taxpayer is essentially seeking to rely upon their failure to follow the legislation, albeit they failed to follow it because they misunderstood, it would seem, the effect of their resolution. But once it's correctly understood that their resolution did not vary the contract and there was a continuing obligation to make payment, it follows that there was a continuing obligation to issue an invoice showing the 1% gross, even though at that time payment was not demanded, and only subsequently demanded with effect from 2006 onwards.
So
I'm worried that your lordships are effectively coming to the point of saying, well, if there's no payment, there can't be consideration.
And the purpose of an invoice is to demand payment. That's what an invoice is.
No, my lord.
And you're submitting that the purpose of a VAT invoice is to do two things. One, to demand payment, and two, to specify the amount of VAT.
No, my lord. It has those two. It can have those 2 points normally, but in this case, it had the second point, which is critical. VAT is a sophisticated tax, and it's important that it's operated correctly. And the Shophold was making monthly supplies. They had decided that for the moment they were going to suspend payment. They had to issue an invoice to show the VAT, which they then had to account for to the Mauritius Revenue Authority.
Well, that was nil, unless you're right in saying that their obligation was to issue an invoice for a sum which they were not charging.
A sum that they had agreed that they were not charging at that time, but which, because of the finding of fact, was still legally due to them.
Well, if they changed their mind later and charged, well then the 5.1a is triggered.
But with respect, my lord, no, that can't be correct. If it's right that there was an obligation to pay, and that is consideration, they should have been issuing invoices accounting to the VAT authorities for that. ShopRite would then have had input tax. If they subsequently decided that they were only going to claim back to 2006, the correct approach would have been then to issue a credit note for an amount that they were not going to claim. But until they decided that they were only going to claim back from 2006, the obligation that flows from the continuing agreement. Your Lordship may be asking me two questions. One of them is, what should they have done as a matter of VAT law? And we say, on the basis that the agreement still stood for both parties, them to supply the services, the subsidiary to make payment as and when demanded, they should have issued VAT invoices but said payment is not currently required. They should have accounted to the VAT authorities, and ShopRite would have had input tax on that. When they subsequently decided in 2008 that they were only going to go back retroactively to 2006, they should have passed a credit note for the amount that they were now no longer going to charge. And that would have resulted in the correct VAT at the correct time for both
Well, I
parties.
think you may be analysing the waiver as effectively a deferral of liability to pay the price rather than a waiver of liability to pay the price. But let's suppose it was a deferral. Suppose you decide, we're not going to charge you for another 3 years. Now, when does the obligation to deliver a VAT invoice arise on that footing?
Let me distinguish two situations, my Lord. If they had decided and reached an agreement that there was going to be no charge for 3 years,
Yes.
and there was an agreement between them, then there is no consideration there.
Then there
but
is
the key point
no
is
consideration until the 3 years has passed.
I'm sorry, my Lord. Are you saying that if they
Let us
decided
suppose that
we're going to defer payment
Yes.
until the 3 years?
Yes.
And then, but they are going to then charge the.
That invoice could be perfectly properly delivered at the point they decide to charge.
No, my lords, because they would surely have accrued month by month. It's Lord Kerr's point. They would have accrued month by month their entitlement to receive that payment, and therefore they are receiving consideration.
Well, I'm putting to you the hypothesis that there is an agreement that payment will be made in 3 years after the supply. Now, on that footing, you would not have to raise a VAT invoice, would you, before the 3 years had elapsed?
No, my lord, that can't be right actually there, because if I buy an item on credit and the supplier says, we give you, what does DFS offer? I give you 12 months credit. Yeah. VAT still has to be charged at the time of the supply, even though they have agreed to defer payment for 12 months.
Where do we find that in the Act?
I think I'm not certain that you will find it specifically stated in the Act. I think it just follows from the way in which VAT operates there, that as soon as I have bought the goods, even though I'm not going to pay for 12 months, there has been a supply to me for consideration, the debt which I owe. If I go bankrupt in those 12 months, they will never get payment. But there has been a supply at the time, and they will have to come and claim bad debt relief because they're now not going to get the money. And that's that. I wanted to leave. I didn't want to take your lordships to the joys of bad debt relief, but it's fundamental. Bad debt relief arises because the obligation to pay is the consideration there, and the result of the finding of the ARC, I can come back to this, but the result of the finding is that there was a continuing obligation to pay. That means that your lordship sort of said, well, I'm treating the resolution as a deferral of payment. In a sense, that is how it must be read, because there was a continuing obligation. They decided in 2003 that they were going to waive the rights. But in 2008, they decided, well, we think you're in a position to pay. And
How did this operate in relation to barristers' fees at a time when there was no legal obligation to pay them?
I hoped your lordship was, I don't know whether your lordship was going to read it. Barristers are different. because we don't have that obligation, we account on a receipts basis and not on an earnings basis.
Right. There's a statutory basis for that, is there?
There's a statutory basis for that for barristers. We are the solicitors. None of your lordships were solicitors. They operate on the. I would call
That's a contractual
basis.
relationship.
Absolutely. If my solicitor does work for me and issues me with an invoice, as he must, I might mentally have decided I'm not going to pay this because I didn't think it was worth it. Or my solicitor may say, I don't expect payment for 3 months or whatever. Nevertheless, invoice goes in, VAT is due. And if your lordships are asking the question, was the correct amount of VAT paid in this case? The answer is no, it wasn't. It was not paid at the correct time by the correct parties.
Yes, but all that is talking about cases where an invoice goes in. I mean, I don't think we need to get distracted by bad debt relief. But my understanding of bad debt relief was that if you submit an invoice, pay VAT on the invoice, and then you don't get the principal sum plus VAT paid to you, then you can reclaim the VAT you've paid. The mere existence of bad debt relief doesn't establish that a contractual obligation is sufficient to give rise to an obligation to pay VAT. I mean, can I take you back to the Act? I mean, I think we're in Section 5.2, aren't we?
We are.
It's periodic payments, and the services are treated as successively supplied for successive parts of the period as determined by the agreement, and each successive supply shall be deemed to take place in 2 circumstances,
Yes.
whichever earlier.
And you've heard my submission.
Yes, but I mean, how do I read into that a further provision which says, because you should have submitted a VAT invoice, therefore you're treated as if you had?
I think you have to read the Act together and note the obligation to issue an invoice and read that into 5.2a. So it is an invoice recognising that there is a legal obligation to issue an invoice.
When the taxable supply is made.
When the taxable supply is made.
And then we turn back to Section 9.2, which takes us back to Section 5.2.
Yes, but if you start from the point that there was an obligation, there's a second answer I'll come to in a moment, but sticking with this point at the moment, if there was a right month by month accruing to receive payment, there is consideration flowing in both senses of the term and in the sense of the European meaning. Therefore, there was a supply. Therefore, there was taxable supply made. Therefore, an obligation to make an invoice there. And I quite agree with your lordship that it does say an invoice is issued. But it would be a very strange situation if a taxpayer could, by being delinquent in their obligations.
Well, it wouldn't be so strange, would it? Because if payment is actually made, then the second of the 2 triggers applies. So you're only actually going to escape liability by not issuing an invoice in a case where you don't get the money. And that doesn't seem, on the face of it, to be such an extraordinary thing.
Well, let me take the second. I think I said 5 or 10 minutes ago that there were 2 answers to Section 5. One of them is, well, there should have been an invoice. And the other one is the meaning of the term payment, because payment has surely to be made, to be understood in the context of Section 12.3. That payment can include, that a taxable supply may be for consideration, which does not consist or does not wholly consist of money.
Yes.
So when consideration is received, for the time payment is received, has to be read as the time that consideration is received. Otherwise, there's a mismatch between 5.2b and
Well, I see the force of that entirely, but it only helps you if you're in a position to say that the mere existence of an obligation constitutes the receipt of value, as opposed, which seems to me not necessarily to be so.
Well, I come back, we get back in circles.
Yeah, we're going.
I think your answer is that, to use a metaphor, You're getting into your back pocket every month an indebtedness, and that can be cashed in at a later stage. So that, you say, is the supply.
Yes, it could be cashed in.
Is there
and
any
was
direct
cashed in
authority on this?
Back to 2006, and could have been cashed in back to 2003. There is, I think your Lordship's probably seen this, there's a logical fallacy in Melania Friend's position, because if there was no consideration, because there was a waiver of payment, that situation of no consideration and therefore no supply continued up to the end of 2007 or the end of, or beginning of 2008, whenever the resolution, there's some difference in the dates, the resolution took place. Therefore, there should have been no supply between 2006 and 2008, but they accept that there was a supply between 2006 and 2008. It must follow from that that there was an obligation to pay and a consideration going back to 2000.
Well, hang on a minute. I mean, do we have any findings of fact as to the basis on which, once the second resolution was made, VAT was paid? I mean, for all we know from the findings, the parent company may have submitted one invoice dated some date in 2008 and say, in respect of that past period, please pay me now the sum of X. And VAT was paid on that sum as at 2008. We simply don't know.
We don't know that, my lord, but we do know that they accepted that there was a taxable supply from 2006 onwards. For there to have been a taxable supply, there must have been consideration.
Well, whether they accepted that as a matter of legal concession or not, I'm not particularly concerned about. I mean, what...
It shows there was a matter of there was consideration, but it doesn't tell us whether the consideration consisted in the payment or the mere existence of the obligation. Yeah. And that becomes rather a crucial difference in respect of the earlier period. But can I ask you this? Is there any authority directly on the question what happens to subsisting obligations to pay money which are waived? Or are we grappling with this as a matter of general principle?
I'm not aware of anything in the Mauritian VAT.
Well, all right, UK or European authority.
General principle. If your Lordship's looking, perhaps this is a helpful point, can I just take some comments on the Norseman case, which Melania Friend relied upon?
Well, I understand you distinguished that on the basis that effectively there was no obligation at all.
Absolutely.
Now, that I entirely understand. But what's the answer to my question about the authority? Has any European or UK court pronounced upon the question whether VAT is chargeable on a payment, the obligation to make which exists, but which has been waived? I think the answer is no. But
the answer is no, my lord, because I think we have tried to find that. What we will...
if the answer was yes, we'd certainly have expected to hear about it.
Can I deal with your answer, your point in two ways? One of them is actually to come back to Norseman, and you are absolutely right that Norseman is distinguishable because the difference there was that there was no agreement to make payment. Here there was agreement, but there was a resolution to not seek the payment at the time. But can I just point you to one thing in the first-tier tribunal decision? This is, I think your Lordship was given a copy of that.
Yes.
The decision of Mr. Colin Bishop, who is the presiding judge of the first-tier tribunal. Just to point out at paragraph 51, I want to remind you that Mr. Justice Warren upheld the decision of the first-tier tribunal. I point to this point, which I accept completely. I accept Mr. Lyle's argument that payment is not a requirement as long as there is an obligation to pay. And I'm willing to also to accept, at least in principle, that as long as a charge has been determined, it does not matter that no invoices...
This is paragraph 51, is it?
Paragraph 51. I'm looking at a different version from the one that you might have, my lords. But I think it was said that Norseman was actually helpful to us, and that point is certainly helpful. Have you got the first-tier tribunal? It's paragraph 51, page 13, between, well, it's line number 17. I'll leave your lordship to read the rest of the paragraph, but that's upheld by the upper tribunal, and we'd say that's an absolutely correct statement. As long as there's an obligation to pay. And with regard to Norseman in the...
But I would have to ask, I mean, does the British legislation have a similar arrangement as Section 9.2 and Section 5.2, do you know?
It has similar wording to Section 9.2. Section 5 is more elaborate in the UK legislation.
Right, thank you.
In what particular respects?
Pardon?
In what broadly respects?
It defines the time in a more elaborate fashion with a number of different possibilities. It doesn't include an ought to be issued obligation, but it does include, for example, that the time will include the time of supply, where it's supply of services.
Right. So there is an anchor to the supply, irrespective of what subsequently happens.
There's an anchor to the time of supply, and then time of supply means
The time of
Is that
performance
really
of the
quite
service.
important with respect, because that would explain what Mr. Bishop, Judge Bishop is saying at paragraph 51.
I'm not certain that I see that Judge Bishop as hanging those statements on the wording of Section 5, but really as a general principle that if there's an obligation to pay, then...
He says what matters is the position at the time the supplies were made. That's the 9.2 point.
Yes. Could I also, I'm not going to ask you to look at it now, but the very last paragraphs of Norseman before Mr. Justice Warren, particularly paragraphs, I think it's 136 to the end. I can leave your lordship to read this separately, but they make the point. Norseman is distinguishable, but there no agreement, therefore no supply. Here we have the scenario of an agreement, which we know is a continuing agreement. Can I just, in the short time, I'm conscious I think my lady friend may wish to reply.
Yes.
On the European cases, you have those summarised in our case, and I don't think I need to take you to any further. Because of the different wording in the European legislation, 4 tests have been developed. Direct link, monetary value, contractual agreement. As we say, all of those are satisfied here. So if your lordships wish only to decide this by reference to the case law from Europe, all of the factors are ticked. Can I just pick up one point that Millennium Fred mentioned? He mentioned the element of subjective value, which is referred to in the potato storage case. And he said, well, there was no subjective value because they valued the supply at 0. I think Millennium Friends has misunderstood the concept of subjective value. Subjective value means that you put on the supply the value that the parties put on it. You do not apply some form of normal or objective valuation.
If they sell too low, you don't charge them the full value.
Precisely. When my solicitor charges me X amount for charging a will, the customs excise don't, Managers Revenue Customs don't come along and say, oh, that's much too much. It should have been an objective valuation.
Well, I should
you
say
get
much
that,
too
my lords.
little.
But lovely, you get that, my lords, if you look at the submissions of the Commission in the potato case. So it's tab 5.
Well, all that tends to reinforce one's feeling that what matters is the consideration that passes, rather than the value of what might have passed.
No, with respect, my lord, I think that's again a misunderstanding. Millennium Friend makes the point on subjective value. They didn't say that our services as a management company are valueless. The services were still of the value of 1%. They decided that because of the temporary financial difficulties of the subsidiary, they weren't going to claim payment. And subsequently, they did claim payment for part of the period. And we say knowing that they were making supplies, and in the light of the understanding of the agreement, they should have been issuing invoices during that time, even if they were not immediately claiming payment. And then subsequently, when they decided only to claim part of the payment, they should have issued a credit note. Junior Mr. Hafsal reminded me, it is implicit in the idea of a credit note that the tax liability arises on the undertaking of an obligation to make payment. Because if you subsequently decide the obligation is excessive and you shall pay less, then you issue a credit note. But you wouldn't have credit notes unless undertaking the obligation was consideration for the supply. I think, my lords, unless there's anything else, I'm going to leave it there, but I have summarised our case in the written case.
Thank you very much indeed. Ms. Ganesh Balaji.
My lords, I do not propose to add anything.
Mr. Bugri.
My lords, to use the jargon of my little friend, I would, by way of the French saying, la réponse du berger à la bergère, have this to say that my learned friend also has been in fundamental error on two issues. The first one, my lords, I've heard my friend say on no less than 3 occasions that there have been concurrent findings of fact on the issue that there was a continuing obligation to pay. I'm afraid, my lords, that this is a finding of law. Had there been a concurrent finding of facts, I would not have been here, my lords. And
I think, in fairness to Mr. Becker, his point is that there was a finding of fact that the agreement had not been amended. That's his point.
yes, I have no difficulty with this, my lords. In fact, in our statement of case, I did agree to this proposition, that this had not been amended, and the facts are certainly accepted. The second point, my lords, is that my learned friend has been labouring on the notion of consideration, and I believe your lordship assumption made it also clear, but may I perhaps refer to one authority in point on the issue of whether one turns to the interpretation of the law of contract, English law of contract, since we may usefully do so, or whether one goes first and foremost essentially to the precepts of the VAT Act. And I believe that it is crystal clear then that one may and does find the answer within the confines of the VAT Act together with the comparable legislation. May I, in this respect, my lords, refer your lordships to tab 7, page 258, and this is the judgment of Battersea Leisure, that is a 1989 judgment, my lords. This is at the held 2, where the proposition is reinforced, and I quote, that consideration in section 3(2)(b) of the value-added tax was not a reference to consideration under English law, but meant something in the nature of a commercial transaction. It could not therefore be said. So this reinforces the point, my lords, that we look first and foremost to the VAT Act. We look at the commercial nature of that transaction. We look at the facts strictly as I believe I have discharged my duty before this court, and therefore we draw the consideration.
What is the, I mean, consideration is not necessary to support a simple contract under most civil law systems. It's a common law concept.
Yes.
What is the position in Mauritius?
We are governed by French law. We have the Code Civil.
That's what I was wondering. I mean,
Yes.
so the law of contract in Mauritius follows the civil code.
The Civil Code and the French doctrine and jurisprudence. And obviously we have
So there has to be cause, but there doesn't have to be consideration.
Yes.
I understand.
Okay. With these remarks, my lords, I rest my submissions. I thank your lordship for your kind attention. Thank you.
Thank you very much. I'm very grateful to Council for their submissions and for, certainly in my case, the considerable achievement of making a case about VAT rather interesting. And of course, we're very grateful also to those who contributed but did not have a speaking role. The board will consider its opinion and let you have it in due course.